Missy, Missy Jennifer Bakst or Baxt.
That's North Broward, Your Honor.
Hi, Miss Baxt. You're charged
Hi.
on count 1 with municipal ordinance violation. Ma'am, are you currently employed?
Yes, I am.
All right. What type of work do you do?
I sell vacation packages.
Do you have any money in the bank?
No.
Do you own any land or property?
No, I do not.
I think Miss B. Is it Fort Lauderdale? No?
Could you throw this over there? That's an ammo.
It's got a 10 case number. Do we know which city? It was from this morning. Do we know which city count 1 is? Anyone? Ma'am, I'm about to, if you'd like me to, count 2, you're being held on a theft charge, which is a state charge. Count 1 is a theft charge, but it's a municipal ordinance charge. And I'm trying to figure out which city is prosecuting you on that. Do we know?
Yeah.
Would you like me to appoint an attorney for you on count 1, ma'am?
I'm a public defender?
Yeah.
Okay, yes.
Give me a moment. I had it. Okay.
Lauderdale by the Sea, Your Honor.
Is it?
Yes, sir.
Do you guys do that?
Page, no, 15, page 15.
Do we know, does any city do that?
I do not know.
Is there a defense attorney for Lauderdale by the Sea? Petty theft. Which city do you see?
Yes, hi. I just called for Jason Hendrick. I got his voicemail. I don't know if he's a supervisor prison. It's an urgent
City of
matter.
Fort Lauderdale.
Someone-
No,
No, the top one, 2901.
it's the City of Fort Lauderdale case. I'm gonna appoint F.J. McLawrence on that.
Here's the thing. This is on an arrest warrant. He prepared the case. The person was an attempted murder.
There you go, ma'am. I appointed an attorney. You're being held on a $1,000 bond total. 500 on 1, 500 on 2, all right? Thank you, ma'am.
Thank you.
Missy Curtis Hoffman.
Okay.
It's a City of Oakland Park case. The City of Oakland Park doesn't appoint counsel. When you originally had him, you transferred him to Judge Norton Wren, and he was in custody for 14, 15 days without an attorney.
It's municipal ordinance.
I understand it's a municipal ordinance case, but the dilemma here is saying if you don't resolve the case, he may be sitting in jail for quite a bit of time without counsel. So would the court consider ROR anything of appointing counsel?
We'll find out here in a minute.
Mr. Hoffman, you're charged with municipal
Brand don't
ordinance
want to do the right
violation.
thing about
Mr.
2011.
Hoffman, Mr. Hoffman.
Yes, sir.
You're charged with a municipal ordinance violation, panhandling in traffic, and the sheriff's office says that you were on the I-95 off-ramp holding a homemade sign reading, "Disabled, in need of work, can you afford a donation?" You said you were wearing- Hold it, let me finish. Green Army camo pants, a green T-shirt reading "Call to Duty," black boots, a gray visor that read West Point, an American flag attached to your sign. And they said that
I was wearing that from Memorial Day, sir. From Memorial Day. Honor veterans.
Posing as a retired veteran, collecting money on Memorial Day. They asked you allegedly, you said you were not a veteran, and they said, this is interesting, I want to put it in the record.
Yeah.
On 2013, you got a trespass warning on 88th Avenue for soliciting in the roadway.
88th Avenue.
Another time in 2013, I guess this is all in Oakland Park, warned not to panhandle on North State Road 7. Last year, warned panhandling in the roadway North State Road 7 at Commercial Boulevard.
Okay. I don't know if you know.
Another time in 2014, arrested for panhandling in the roadway. June 2014, a traffic citation for panhandling, State Road 7, in the roadway. June 25th, warned to leave because you were holding up a sign panhandling at West Oakland Park Boulevard. August 9th, 2014, trespass warrant for panhandling for money in the roadway. August of 14, arrested for soliciting in the roadway. September, arrested for soliciting panhandling in the roadway. Again, the same month, panhandling in the roadway, arrested again. Then right here, October of last year, warned and observed walking in traffic, knocking on people's windows for money.
I did not do that, sir.
Yes, sir.
I don't do that because it was not on any of the other ones. I know, but people are lying.
And then,
as you say, you've been sending
May 7th
cases.
of this year, arrested for panhandling in the roadway at the same location, 62nd Street at the I-95 off-ramp.
Yeah, yes, sir.
You said that
Yeah.
Hoffman has also been trespassed from all Florida Department of Transportation properties, including all I-95 off-ramps, underpasses, overpasses, and bridges.
No. That's not true, Judge Hurley. I haven't been trespassed, and I haven't got no warnings.
Right.
The problem is this, that you've been sending everything to Judge Wren, and it appears that I filed in loss of my inheritance in U.S. District Court, case number 0961588. Appears my brief was due in the United States Court of Appeals, and I was attacked in an assisted living facility same day as the mental health task force meeting with Judge Spicer, Hari, and all that in the sheriff's office of Pompano Beach. Falsified a battery of a disabled person, a home invasion, a hate crime as a misdemeanor to send the United States Court of
Let me
Appeals.
ask you a question. Do you have any money in the bank?
Yes, sir.
Do you have money?
No, I don't.
Do you have any way to bond out of jail today?
No, I don't.
Okay,
If you could pre-trial or send...
Based on just repeated behavior of this type, and you've been warned, I personally have warned you many, many times to stop.
But you
doing
know
this,
I outreach the
knocking
guys
on
in front of the
people's
courthouse.
windows. It
I
appears that
outreach
you're not
Charlie and
inclined to
stuff.
do it, to stop doing it. So I'm going to set your bond at $1,500.
That's how I support my outreach, to help other people. I got to get some money somehow.
$1,500. I'm going to appoint attorney Steve Shade to represent you. And
Well, he doesn't want to talk
I'm
to me.
going
Can I get somebody
revoke
else?
your bond on 152089 CF10. That's the cocaine case you have open right now. You'll be held without
I'm
bond on that
pre-trial
case.
for that. You can just ROR me,
Thank
sir.
you.
My stuff will get stolen.
Yes, sir. Good
I
luck.
have a can.
You want that?
Come on, Judge Hurley. Just this is helping me here.
Thank you.
On top of conspiracy to everything else.
Yes, sir. Thank you. Daniel Holzman.
Go ahead, man. It's Hoffman. Go ahead. Go ahead. What we doing, man?
I thought you were going to help me get out of here. ROR.
I can't. It's an MO
Now,
case.
move out of the way, Mr. Hoffman.
Let's go.
Good luck, Mr. Hoffman.
Thank you.
Nope. It's an MO case. Halsman, right? Yeah.
All right. Holzman. Trespassing, sir.
Yes, sir.
Sir, trespass warrant in the city of Sunrise.
Yes, sir.
Consuming alcoholic beverages in public at around 4 o'clock in the afternoon. And you have another municipal ordinance. Oh, that's a trespassing. And then count 3 is another trespassing from this year. So you have 2 trespassings and drinking in public. Now, count 3 is a warrant for $500 Count 1 is 25. And count 2, I'm going to just release your ROR. Thank you. Excuse me. How about,
What you mean on
how
you don't have
about
to
Ron
post a bond on that
Cespedes? Ron Cespedes.
Man, I work at that way.
Mr. Cespedes, municipal ordinance violation.
Yes. How can I
Court
help
finds
you?
probable cause.
What's your name?
Do you have any children?
Right.
Do you want? How long have you lived in
I'm sorry?
South
How old are they?
Adjudication type, sir. We just asked, does he have any priors, you know about?
How many children
Tell
do
me
you have?
about his
4?
priors.
And the age?
Are you working at this time, Mr. Cespedes?
Yes, sir.
What type of work is that?
I do warehouse, unloading trucks.
What's your take home pay?
Anybody in your family here? Yes.
How much was it last week?
Okay.
I'm sorry? Put a 0, put down 300?
Anything else?
Sir, if you'd like to resolve these today, I've spoken, well, let me ask you this. Can you afford to hire your own attorney, sir?
Oh, I can't.
Okay, so, apparently you've spoken with, Mr. Atria. He spoke to you over the phone about this, correct?
I haven't spoke to nobody.
Did you have an attorney speak with you over the phone about this, sir?
No, I haven't.
Okay, hold on. Have you spoken to anyone, any attorney about resolving this case?
No, sir.
Circle these no's, these no's, these no's, these no's, these no's, start down hard. Hold on, just put your hand, start circle the nose and the bit of the
Yeah, right now, yeah.
So, I'm
Yes,
gonna
sir,
point,
yes, sir.
I'm gonna, okay, I'm gonna point, Mr.
Carl.
Do you know anybody
Lawrence
else?
on this. So, now, sir, would you like to plead no contest? If you want to, you'll be adjudicated guilty. I'll give you time served, case is over with. You just have to pay a minimal fine. I'll give you 6 months to pay. Is that what you want to do?
Yes, sir.
Sir, do you understand you don't have to do this? You could have a trial. You could have your day in court. And you could call witnesses on your behalf. Your attorney could represent you at trial. But if you plead guilty right now or no contest, none of that's going to happen. It's wrapped up right now. Do you understand that, sir?
Yes, sir, I understand.
How do you plead?
No
I'm
contest.
going to adjudicate the defendant. Time served. Thank you, sir.
Thank you.
Okay. Now, we got one more, a couple more.
Pickering. Turn your neck down. Pickering on page 4. I need photos. Right here, the first guy, I forgot to tell you. Sign print address.
Marquise Coleman,
Bonded.
Jeffrey Quolick,
Mr. Quillen.
Sign print address, city street, code phone number.
Hey, how are you doing?
A little rough.
Good to see you, Mr. Quolick.
Good to be seen.
Yeah. Mr. Quolick, you're charged with trespassing, municipal ordinance violation. They said you were over at the. Said you were trespassing in the hotel lobby at the Embassy Suites, sleeping on the bench outside of the men's room. Previously warned not to be there. So, all right. What do you want to do? Mr. Quolick's been in here a bunch of times. Usually it's over at the Pollo Tropical, right?
Yeah.
Yeah. All right. How do you feel about this?
Yes, is this Jackman?
I kind of like Mr.
Hey, it's
Quolick,
Eric
to be
Bender.
honest with you. Nice guy.
Hey, could you
He's from
confirm
Michigan,
something for
right?
me? 'Cause,
Yeah, Detroit.
one, I believe that Jules
Got to know him over
has
the
a
years.
custody case. The defendant's name is Shayna Donovan.
Well, he's been in here a lot of times, but he's a
I
nice
was hoping
guy.
if you could confirm for me that the charges are,
Well,
the alleged charges are burglary,
Mr.
the
Mr.
battery.
Quolick's
Initial here, initial
Mr.
here.
Quolick's deviations from lawful activity are, they're not
Here,
bad.
initial here.
Not that serious.
You want?
He's got a good heart. He's a Midwesterner. He's from Michigan.
I don't have the time.
Hey.
It's
Embassy
paperwork for the
Suites.
public defender's
I think
office.
that's
If it wasn't
reasonable.
public, you don't do anything. Initial
Let me
hearing-
ask you, did you have a chance to speak to anybody on this?
Initial hearing for your records. Release information.
Okay. Mr. Quillick, we have an attorney here working on your behalf, Mr. Atria. I know you can't afford an attorney. I'm going to go ahead and appoint Mr. Atria to represent you in this hearing, all right?
Sure.
Okay. Well, it's going to be McLawrence.
Let me see if I can.
Now,
Yeah, it doesn't put it at the top. It says I
the
clean out
court's
Richards.
inclined to just let you resolve your case, plead no contest, and we'll just adjudicate you and give you time served. How does that sound, Mr. Quillick?
That sounds great.
With the understanding that you're not allowed to step foot on the property of Embassy Suites ever again. How's that?
Understood.
Okay. Now, you understand if you plead no contest, you're adjudicated guilty. You're not going to have your day in court. You're not going to have a chance to have your attorney defend you in court. The case is wrapped up right now. Do you understand that?
Yes, I do.
Okay. How do you plead, sir?
No contest.
All right, I'm going to adjudicate you, give you time served, and it's good seeing you, all right?
Good
Take
seeing
care
you,
of yourself,
Judge.
okay?
I will.
Take care, Mr. Quillick.
Thanks.
All righty, sir. Go outside and have a seat, Mr. Product.
Okay, may I help either one of you two women right there, second row?
That's not his.
Mental
real
problems?
name.
Excuse
The
me?
warrants are his real name is.
Okay. Any other, I think that's it. Is that it?
But I just got.
Yeah, you can give me that.
Michelle Rivera.
Second look paper on the podium there.
That's the question.
He's taking a quick step. He's gonna get back.
We just need to know.
Where's Michelle
Mr.
Rivera?
Beer?
Paul Ryan, right here, Your Honor.
Now yeah. Now the warrant is for a candid witness, but his real
Petrie?
name is Candid.
What's the municipal ordinance Ms. Rivera was charged with?
MERVIP.
Mr. Robinson?
That's everything for him.
Deputy Attorney. Deputy. On page 4, Richardson. You still like MIA?
So hopefully they get in touch with us.
Reset.
Mr. Atria, it appears there's a Waller Bennett on page 10 of the afternoon docket that might be yours.
You want a public defender?
Waller Bennett, page 10 of the afternoon docket might be yours.
What are you gonna do, sir? Private attorney or public? I'm sorry? Sign right here, this is your amendment. Do you have any children?
Page 10, Bennett,
Sir?
at the Conti.
Ma'am, do you have any money in the bank?
The program I'm in has all use of all my funds.
Well, okay, do you have any
So-
money in the bank?
I get a check every month.
Okay, do you have any money in the bank?
I should every third of the month I receive
All
disability.
right, as we are sitting here right now in court, do you have any money in the bank?
As far as I know, I should have some with paying my rent at the program. I just went into a program. I was living
Okay,
on house
ma'am,
arrest.
I'm gonna, one more time. Do you have any money in the bank? Right now?
I should.
How much
I should
do you
as far
think
as
you
I
have?
know. After paying my rent and the food there, I should have around, let's see, 8, maybe 600,
Okay.
close to 650.
Do you own your own house?
No.
Are you currently
no.
employed?
No.
Okay.
I had a condo. During that year, I'm all messed up with someone I had met who it was all a blackout. I had a seizure. I almost died.
Boy, I tell you, ma'am. Hold on, ma'am. You really don't need to. Go ahead.
Okay. I'm just trying to tell him from day one.
Okay. All right, ma'am. Thank you. Your bond is posted on the municipal ordinance, but on the other case, you have a no bond hold. Thank you, ma'am.
Okay.
Okay. What did I do on Marquise Coleman? Have I handled that yet? Who bonded? Marquise Coleman bonded? Oh, you're here for Marquise Coleman.
Yeah, it's first domestic.
Sure. Okay. Uh-oh. Let's see Tia Townsend.
Main jail. Decline PD.
Ma'am, you're charged with battery. Court finds probable cause. State, do we have any prayers on Ms. Townsend?
No, Judge.
Sir, did you have any contact with the alleged victim? Got it. Okay. Would you like to step up here, ma'am? You bring with you. Miss Adderley, come on up. Are you related to Chief Adderley? Oh, okay. All right. Can everybody raise their right hands? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Put your hands down, ma'am. Tell me your name. And you're the mother of Miss Townsend? Now, where do you work?
Minor free trial and another case.
You work there too, ma'am? You work for the clerk's office. Okay, there you go. All right, and just tell us your name, ma'am. How do you know Miss Townsend, Miss Adderley? Great, okay. Well, she's got no criminal record. This was a incident allegedly occurred at a pickup drop-off of the child, and so she grabbed Mr. Hyman, and I'm not going to get in specifically on what she allegedly grabbed, but suffice it to say, I imagine that it was a painful issue. So do you have any comment about it?
Just gonna ask that there be a no contact order.
All right. He doesn't wish to cross. I'm going to release her on her own recognizance today. All right. So she doesn't have to bond out, but I'm just going to order that for the time being, she has no contact with Mr. Devin Hyman directly. She can have indirect contact, picking up and dropping off the child or children. Could you just arrange that? Do you know him well enough to talk to him, ma'am? Is there someone else you could use to work this out? Is there a pastor or something you could use? No? Who has the child most of the time?
Why didn't you just come up the middle if you were sitting right there? Go around the long way. Do you have an attorney? Are you gonna hire your own, or do you want a public defender?
Is there any way you could email him or do something like that, or text him, try to work this out where you can work out pickups and drop-offs for your children?
Do you have any children? Zero pressed down hard?
Yeah, I've done as much as I could do. So,
Thank you, Judge.
I'll allow indirect contact regarding the child, but, stay 500 feet away from Mr. Hyman at all times, ma'am. And, if he's got a right to see the kids, work that out. I'm not saying he can't see his kids. I'm just saying work it out through a third party, all right? Not allowed to possess any guns or weapons while you're out. Thank you. Anything else? Okay. Thank you, Miss Adderley. Thank you, ma'am.
Good luck.
We're going to call you next. All right.
No, maybe not.
Do you live in it? Then we can't put it down. I know what I'm doing. Credit card, what are you
I don't even know.
Could you hunt around for it? Let me call the next case up. Okay, ma'am, step forward. May I see Matthew Pickering?
In the world.
Pickering's present at the main. We need a photo order for Mr. Pickering, Judge.
Mr. Pickering, you've been charged with aggravated battery on a pregnant female. The court finds probable cause. Let me make a disclosure. The woman standing in court at lunchtime asked me where the courtroom was, and I told her where the courtroom was. Other than that, I had no discussion with her about the case. So, is that, ma'am, would you agree that that's, you and I didn't talk about what happened or anything like that? I even told you that I wasn't allowed to talk to you about what happened, right? Okay, good. Now, will you raise your right hand? Do you swear or affirm to tell the truth, whole truth, and nothing but the truth? Put your hand down. Tell me your name. Amanda what? Roman? Okay, ma'am. How is it you know Mr. Matthew Pickering? Unborn child. Okay. And how far along are you? Boy or girl? Yeah, you picked out a name. Aaliyah. Great. Okay. So, now, does this gentleman have any criminal records, State?
No, Your Honor.
Now, ma'am, tell me about Mr. Pickering. Is he currently employed? What type of work does he do? Okay. Does he help support you up to this point financially? Are you currently employed? Okay. And when you work, what do you normally do?
I do like reception.
Got it. Okay. Now, do you have family down here in South Florida? Does he have family down here? How long has he lived down here? Do you know? More than a couple of years. Does he own any? Do you know that he owns any houses or any land or anything like that?
Prior felony.
Go ahead.
Showing one thing I see, once in 2013 and again in 2014, a different woman, it looks like tried to sought to obtain a temporary injunction order of protection against Mr. Pickering. Additionally, he's had a couple of prior possessions of marijuana in 2012.
Got it. Now, ma'am, let me ask you a question. I'm looking here. It says that you went to the sheriff's office and complained that he had battered you. Did that happen? Okay. Tell me what happened. Why did you go to the sheriff's office? Well, tell me what happened. Did he grab you? What happened? Right.
Mr. McGovern?
This happened yesterday? Okay. Now, do you ever know him to carry any guns or weapons with him, ma'am? No? Okay. Now, you injured by what he did to you? You have bruises on your arms? Okay, you're going to have to go to the doctor?
I did. I went to the hospital yesterday.
Okay. Are you going to be okay?
Yeah.
About yourself? You have any children?
Baby was?
I'm sorry?
That's what
They
they
live
told
with
you
you?
at the hospital? Okay, now, is this an isolated incident, or has there ever been another time that he was physical with you?
What did they say?
Tell me the other times, tell me about when they occurred.
From 75, we get assistance from the government, so security, funds, and stuff. Property, pension, mobile, funds, money market, city.
Okay.
Circle these nodes, and these nodes, individually press them.
What did he do then?
It was the same thing, just not as bad.
Grabbing you?
Yeah, just grabbing me, but not physically, like, assaulting me as if, like, he did yesterday.
Are there any alcohol or drugs involved in any of this, ma'am? No? Okay. And
I want to go to the credit card, hospital bills.
says he grabbed you, threw you against the wall a couple times, hit your head on. Says he hit you on the side of your head, then grabbed your throat, threw you on the bed, bruising on your arms.
14.
Okay, and
Any brother bruising any?
okay. Anything else you'd like to tell me today, ma'am?
No,
Are you in fear?
I'm not in fear for myself. I'm just concerned, like, for the safety of my daughter.
Okay, well, I guess that goes hand in hand, right? Okay, so you tell me what you're in fear of. Do you think he would come if I let him out of jail? He'd come do something to you?
No.
No? Do you think you know him? Is he the type of person that if a judge tells him not to do something or to do something, he would follow the judge's order?
He would follow me.
Okay. All right, and State, anything you want to say? I'll let Mr. Miller close it out.
I mean, I'm concerned because I'm seeing certain red flags. One, in this case, we're seeing increased violence, a higher level of violence as time goes on, and there's no reason to believe that it's going to all of a sudden, any future violence will decrease. It's most likely based on studies will become more serious. Additionally, Your Honor, she's not Ms. Roman is not the first woman to allege violence by Mr. Pickering. Another woman on 2 separate occasions sought a judge to issue a restraining order against him.
Okay. Mr. Miller, anything you'd like to say?
Judge, 6-year resident of South Florida, 4 years at the same address. He's got a job at the AutoZone, IMC AutoZone. He has a 2-year-old child and one on the way, apparently. Strong family ties. He has $62 in the bank, Judge. No real estate. Does have a place to stay separate from the alleged victim. He is going to have to self-bond, and as far as I know, Judge, he's never been charged with violating a court's order to stay away from anyone. So, and he's assuring me that he will not disobey this court's order should the court require there to be no contact.
So the court does note the escalating violence, which is in the report, and the court does note that there are at least 2 other prior times there was violence in this relationship. Court notes the level of violence: grabbing a pregnant woman, throwing her onto the bed, throwing her against a wall. She ended up hitting her head. She said you grabbed her throat. The court notes you have 2 prior restraining orders that had to be taken out against you. The court also notes the unique vulnerability of this alleged victim, that she's visibly 6 months pregnant, as you said, ma'am. Am I correct? And the court does note there are some injuries here, and you did have to go to the hospital, and you were concerned about the safety of your child, and they even said that these actions had an effect on your health and the baby's health, correct?
Yeah.
Okay. So the court's going to set your bond today at $10,000. Based on that level of violence and what the court set forth so far, the court will order you have no contact with Amanda Roman. Do not call her, do not text her, do not email her. Stay 500 feet from her at all times. That is where she lives, works, goes to school, anywhere in between. You're not allowed to possess guns, firearms, or ammunition while you're on release. Ma'am, I could take one step further. I could put an ankle monitor on him, GPS, to ensure that he doesn't come near you. How do you feel about that?
It's okay. He'll stay away.
You don't think I need to go there? Okay, thank you very much, sir. That's it, thank you. Okay, ma'am, which case are you here on? Kendra Wallace? Kendrick Wallace. Can I see Kendrick Wallace, please?
Come here. Contiona.
Okay.
It's on the second document. It's on the second document.
I understand. Pull it up here.
Your Honor, I can handle this if we haven't brought up.
Go
This
ahead.
will be pretty quick.
Hey, ma'am, raise your right hand. Do you swear or affirm to tell the truth, all truth, and nothing but the truth? Put
Yes,
your hand
sir.
out. Tell me your name.
Kendrick Wallace.
Miss Gordon? Okay, ma'am, thanks for coming to court today. Where's Mr. Wallace? Do we have him up there?
Conti, Your Honor.
Okay, ma'am, how do you know Mr. Kendrick Wallace? Really? How long has he been your boyfriend? Really? Okay, there you go. Is he a good boyfriend? Yes. Is he? All right.
Your Honor, this is a 30-day motion. The state's filing charges. However, we're filing a trespass charge. I have no objection to being ROR. I would ask that Your Honor, again, remind and order Mr. Wallace he is to not have any contact with the alleged victim, Susan Rubin, and not return to the location at 1741 Southwest 4th Street in Fort Lauderdale.
You understand that, sir?
Yes, sir.
All right, no contact with Reuben, no contact with that address, all right? All right, it's hereby granted. All right, ma'am, are you ready to have him come home?
Yes, I do.
All right, 15-5287 CF10. The ROR will be granted. The defendant will be released from custody. Ma'am, I want to thank you for coming to court and getting all dressed up. I mean, you really got all dressed up today, didn't you? You look great. Can I tell you? I like the ribbon and the whole, you look good. So this is some good news for you. And I hope you have a nice night, all right? And I hope you two, he may not be out by dinner time, but maybe a kind of a late evening, all right? Okay, good luck, ma'am. Thank you for coming, all right?
Yes, sir.
Okay. All right.
You'll take that?
Thank you so much, God bless
Okay,
you.
apparently I'm entertaining the clerk's office over here. I can't get to the
That's
bottom
not-
of
that's
why
a- that's
they find me so funny,
The
but,
nicest way you
all
could
right,
put
that
it.
being said, we're gonna move on.
What's
Shavanda
that? She's
Dorset.
given me before.
Ms. Dorset, you are charged with domestic violence battery. The court finds probable cause and allegedly slapped another person on the face and the head, shoved her into a wall, grabbed her by the hair and threw her onto the ground. State, do we have, and then once on the ground, allegedly kicked her and choked her. Go ahead, State.
One moment. 2007, he was arrested for, or she was arrested for domestic violence battery against a different alleged victim. Convicted of battery from 03, 01, dealing with stolen property and theft.
Okay, so 2 prior batteries. Mr. Miller, anything you'd like to say?
20-year resident of South Florida, 9 years at the same address. She works for Primary Electric. She's been there for 2.5 years. Strong family ties. She has a little money in the bank, a place to stay when she gets out, and her family's going to bond her out.
Ma'am, based on your criminal record, a prior domestic battery, a prior misdemeanor battery, and the theft, I'm going to say, and the facts of this case, court's going to say you're bonded $7,500 today, ma'am. The court will order that you have no contact with Dina Wesley, directly or indirectly. Don't call her, text her, email her, no notes, no letters. Stay 500 feet from her at all times. That is where she lives, works, goes to school, anywhere in between. You're not allowed to possess any guns, any weapons, any firearms while you're on release. Thank you. I'm going to take about a 1-minute break. I'll be right back. All right. Shayna Donovan, please.
Do you want to call both co-defendants, Your Honor?
Yeah, I got them both. Troy Holloway.
Donovan's in North Broward.
One's at the North Broward jail, one's at the main.
Where's Shayna Donovan?
At North Broward jail.
North Broward.
Shayna Donovan, you are charged with burglary with a battery.
Yep.
And count 2 is a battery. Troy Holloway, you're charged with burglary with a battery. Count 2 battery. Count 3 criminal mischief. Now, count 1 on both of you is a first-degree felony punishable up to life in prison. Now, State, are you seeking a foreclosed bond and release conditions on Ms. Shannon Donovan?
Yes, Your Honor.
Are you seeking a foreclosed bond and release conditions on Troy Holloway?
Yes, Your Honor.
Okay, I'm gonna let you go ahead if you don't
Your Honor,
mind.
I'm going to be relying on the PC affidavit from Deputy O'Brien of BSO, where sworn statements were taken from both Ms. Holmes and her 2 sons. Your Honor, based on the allegations charged, I believe that there is proof evident that Ms. Donovan and Mr. Holloway committed burglary with a battery. First off, they could not legally enter that apartment because, according to the report, there is a court order that they are not allowed to have any type of visitation with their children, who Ms. Holmes is the foster parent for, without supervision. So they legally, to begin with, couldn't enter that apartment where the children were located.
Right.
It's alleged they entered without permission, and then once they're in, committed batteries against several of the people inside the home, Your Honor. And I just think that the report is with enough specificity from sworn statements taken from all 3 alleged victims to satisfy proof evident at this time based on the probable cause affidavit.
May I briefly respond? I'll just say one thing. It seems kind of hazy as to where the altercation took place, because it said it spilled outside. I don't recall seeing anything in the probable cause affidavit that says any damage. A altercation where things are being thrown around, I may be incorrect, but I'm just looking at the PC and I just don't see if there
I can
was.
read right here. Winston told the defendant, that's Miss Donovan, to leave and attempted to close the door. At that time, there was a struggle over the door between Winston and the defendant. During the struggle, the defendant and co-defendant unlawfully entered Lenita's apartment, initiated a physical confrontation by forcefully pushing Winston backwards in the process of entering. They were told to leave several times by Lenita and Winston and the son, but they refused.
Judge, just going back, if they were inside the house and you're having a fight between four or five people involved in the house, did the officer observe anything inside the house that was anything out of place? I mean, that's
You could
why.
have somebody come to somebody's house and stab them in the chest 3 feet inside of the door, and there'd be nothing out of place in the house. You know what I mean?
Well, it says that they went inside the house and they started inside the house. Was there any damage inside the house or any signs of struggle witnessed by the officer that responded to the scene?
Pushed Winston up against the wall, causing him to collide with a mirror and receive a laceration of his left wrist when it shattered. I'm assuming they don't have a mirror on the outside of their house, they have a mirror on the inside of their house.
And it does mention in the first page that he was receiving, or at some point receiving treatment for injuries.
So, all right, and what about Troy Holloway?
Well, Your Honor, I think it applies to, I'll make the same argument, it applies to both of them, Your Honor.
Do you have any response regarding Troy Holloway?
Didn't get a chance to read his probable cause affidavit. I spoke with only Ms. Donovan. I don't. Is it the same thing? Same duplicate?
It says,
I have nothing with regards to him, unless Mr. Miller has something.
Okay. Give me a moment. Okay. Mr. Shannon Donovan, ma'am, court's gonna find count 1, burglary with a battery. There is, yes, ma'am. Do you have something you want to say? Tell me what
Yes,
it's about.
ma'am.
Just tell me what it's about.
Your Honor, the only thing I'm guilty of is
Don't
knocking on
talk about the
door.
facts of the case. Remember what we talked about earlier? Everything's being
Yeah,
recorded.
Court's gonna find proof evident presumption grade has been established today. And I'm gonna order on count 1, you'll be held without bond.
Judge, with a court order a medical screen.
I'll
She
order
may
a
be
medical screen.
She's pregnant.
Note, the defendant is pregnant. And, also, ma'am, count 2, your bond's gonna be $1,000. The court will order no contact with Winston Job, Lanita Holmes, and, LaShawn, who's it? Lancaster. No contact with either person. Thank you, ma'am. You're gonna be held without bond. Now, Mr. Troy Holloway, court's gonna find proof evident presumption grade for count 1. You'll be held without bond on 1. Count 2, your bond's $1,000. Count 3, the criminal mischief will be $100.
Your Honor, I'll wait till you're done with the release.
You
conditions
are
on
not
this
allowed to
case.
have any contact with Winston Job, Lanita Holmes, and LaShawn Lancaster, yes.
There's one other issue, Mr. Holloway. He is currently on probation for domestic violence battery in front of Judge McHugh. Ironically, Ms. Donovan is the victim in that case.
What's the case number?
1320561 MM10A.
Got it. Got it. Okay, sir, you're gonna, bond is gonna be revoked on 1320561 MM10. Thank you.
Your Honor, that's a 94806.
Yeah,
Okay.
not bond revoked, it's a probation hold. Jason Cialo. Mr. Cialo, domestic battery and possession of cannabis. Court finds probable cause. Steve, do we have any priors on this gentleman? Do you have anything you'd like to add on this while we're waiting, Mr. Miller?
If you don't mind, I'll wait till the state.
Just so you know, first off, he is on.
Come on up to the front row. Quiet down, guys. We'll walk there. Sit in there. Be all right. Ain't gonna burn you.
He's in here left. It's just a group.
One of those switches. Right up there, right up there. Just off right there. If you tell them how you get back.
Okay, Your Honor, out of New York, issuing bad check 07.
What? What about it? Yeah, you gotta go. Once you go get it, you go right.
Out of New York?
Yes.
251.
Got it. What, a bad check out of New York in 2007, Mr. Miller?
Judge, I think this case is one of unintended consequences. I don't think that Sciallo intended to chip the tooth of the alleged victim in this case. I think there may have been an altercation, but I don't believe that the amount of damage done was intended. Been living in South Florida for about a year. He's an entertainer, strong family ties. He has family living here in South Florida. No money or real estate. He does have a place to stay separate from the alleged victim while this is pending, and he's hoping that his family will bond him out. We're looking for a pretrial release on this, Judge.
Did you have contact with the alleged victim? No? Okay. Allegedly swatted a wine glass up in somebody's mouth, cut their mouths. 3 independent witnesses plus the alleged victim all say it was intentional. So the court's going to set the...
Judge, I never said it was unintentional. I said the damage was more than was intended.
Oh, I can imagine that. So, so the court's going to set your bond today on count 1 at $3,500. Count 2, that's a ROR on 2. And the court does note you do have a prior bad check out of New York. The court's going to order so you have no contact with Ryan Twist. No contact with Ryan Twist, directly or indirectly. Stay 500 feet from him at all times. That is where he lives, works, goes to school, anywhere in between. You're not allowed to possess guns, firearms, or ammunition while you're on release. Thank you. excuse me. How about Ricardo Burks? Ricardo Burks. Mr. Cielo, please step to the side. Mr. Cielo, please step to the side. Thank you. Ricardo Burks, so you're charged with domestic battery. Court finds probable cause. Do you have any priors on this, gentleman?
One moment.
Sir, do you have any contact with the alleged victim?
Yes, the victim explained that it was a one-time thing, that she's not afraid, that
Okay, allegedly struck a woman with a closed fist on her chest and abdomen, grabbed her, picked her up, slammed her on the ground, started to drag her by her arm and hair, northbound. And they found she had damage to the hood and windshield of her vehicle. Redness and she had a bite mark allegedly on her forearm. Go ahead.
He was arrested on May 24th for disorderly conduct.
Okay. I assume it's still open, right? Anything else on this gentleman?
Lifetime resident of South Florida, 19 years at the same address. He works at Winn-Dixie. He's got the child on the way that he'll be taking care of with strong family ties, no money or real estate. He does have a place to stay, separate from the alleged victim while this is pending, and he's hoping that his mother will help the bond amount.
Hold on. One moment, Judge.
Okay. Just give us a quick moment.
I'm not yelling. You have a very different Yeah, he bonded out, Judge, so I'm sure it is open.
So he bonds out and gets arrested within 24 hours.
Yeah.
Pretty much.
Okay. So I'm going to set your bond today based on the level of violence. You're already out on one crime, disorderly conduct. Now you allegedly say your bond at $4,500 today. Order based on the level of violence. Court's concerned for the safety of the alleged victim. No contact with Kayla Zesny. No contact with her directly or indirectly. Stay 500 feet from her at all times. That is where she lives, works, goes to school, anywhere in between. You're not allowed to possess guns, firearms, or ammunition while you're on release. Thank you. Missy Anthony Kiera. Sir, you're charged with, you have 2 warrants on felonies, count 1 and 2. Count 3, domestic battery, 4, tampering with evidence. So, State, do we have any priors on this gentleman?
One moment, Judge.
Allegedly struck with a closed hand his girlfriend of 1 year, Jessica Greenberg. And then punched her in the right eye with his fist. Continued to strike her in the back of her head, causing her to fall on the floor. The police observed a black eye on her right eye, bruising on her left eye from the struggle.
Whenever you're ready, Judge.
Go ahead.
Your Honor, you had a theft last year, grand theft 2013, grand theft auto 2011, just over 18 months. 2011 grand theft auto with a VOP, just over 18 months. 2011 possession of methadone with a VOP, just over 18 months. 09 Berg structure, grand theft. 09 Berg structure. 07 attempted Berg structure. Your Honor, we've also, just so the court's aware, we've also received information that Mr. Kyra, since he's been in custody, has contacted the alleged victim, seeking essentially to hope the charges will end up being waived or dropped.
Okay. Did you have contact with the alleged victim?
she said that she just wants to let the process go, but she's concerned about his refuse.
Got it. Mr. Miller?
Lifetime resident in South Florida. He works at Woodcraft Custom Designs. Been doing that for 14 years. He has strong family ties, no money or real estate, and he's hoping that his family will follow him.
Sir, 5 prior theft convictions, 2 burglaries, attempted burglary, and meth. So, and I look here, you're 26 years old, and you've already collected 1, 2, 3, 4, 5, 6, 7, 8 felonies at 26 years old. So now you're here allegedly beating, for lack of a better word, physically abusing, beating up your girlfriend, punching her, giving her a black eye. She says she's concerned about your drug usage. So, court's going to set your bond on count 3 at $8,500. Count 4, court's going to set that bond at $1,500. Your total bond today, new bond, is $10,000. However, you're going to be held without bond on count 1 and 2. Your bond's been set based on your lengthy criminal record and the level of violence. The court's concerned for the safety of Ms. Greenberg. Sir, the court's going to order no contact directly, or Mr. Kara. Mr. Kara, sir, you may want to listen. You're not allowed to have any contact with Jessica Greenberg. Directly or indirectly, no contact. No telephone calls from jail. No telephone calls, text, emails, directly or indirectly. You're not allowed to get a message to her through a third party. You must stay 500 feet from her at all times. You are not allowed to come within 500 feet of where she lives, works, goes to school, anywhere in between. You are not allowed to possess any guns, firearms, any other weapon while you're on release. Go ahead, sir.
Excuse me, sir. She's supposed to be coming down here today to sign a waiver.
How would you know? I'm not even going to.
This is through my father.
Yeah, I'm sure. I'm sure through your father, right?
She couldn't make it into court today because she's on community control.
Oh, I'm sure you heard that through
my
third
grandfather's.
person.
At my grandfather's, yes.
Let me put it this way. If the court finds out that you are contacting her through a third party, the court finds that out.
What if she comes up there and signs a waiver, sir?
You don't have to have this conversation.
I just want to ask.
You know, sir.
If she signs a waiver, that's what I want to know. I didn't ask her if she wants to do that.
I'm sure you didn't have anything to do with it. I'm gonna give me
I was
an order
on
to
drugs.
cut
She
off
was
his
on
telephone
drugs.
privileges.
So.
Sir, I'm going to cut your
One second. Stop
I'm
talking.
going to cut your telephone
Judge.
privileges off right now.
Judge.
Go ahead.
I'm sorry.
If there was a phone call made, as the state has asserted, okay, it was done prior to any order from this court or any other court that he not have contact with this person.
Sure.
Okay, he has not, you've given him an order, he has not disobeyed your order. You're getting ready to take away his telephone privilege. He hasn't done anything yet.
Well, I disagree. I'll tell you why I disagree. There is a difference between reaching out and saying, make sure you pick up the kids from school, and tampering with a witness. Now, I don't need to pre-warn someone to not tamper with the witness. When the phone call from jail is, hey, get down there and sign a waiver, that's tampering with a witness on its face. That's why your
Your
phone
Honor,
privileges
you
will
have
be
no
cut off.
information. The court is acting on no information. You
No,
don't
I
know
am.
what was said during that conversation.
I've been.
You just know that a phone call was
No,
made.
I've
That's
been
it.
told from the prosecution that the victim says that.
Your Honor.
Hold it. We're going to clarify. Just give me a moment. Go ahead.
Your Honor, can we go sidebar? Mr. Fossil will still be here.
Let me ask you this.
We found it based on our investigation, Your Honor. That's all I can say without getting specifically how we obtained the information.
Defendant's not going to have any contact with anyone else except his attorney or an agent of his attorney. Defendant's not allowed to have any visitors except his attorney or an agent of his attorney. Not only
Judge
based on
Jackie, my
what the
client has
court
committed
just...
no crime. He's not disobeyed any court's order.
Thank
This
you.
is over
The court's ruled. We're moving on.
and anticipatory. Until he does something wrong, the court has no reason to hold him incommunicado.
Yes, sir. Thank you. May I see Robert Jackson?
No Broward Jones.
Excuse me. Oh. Mr. Robert Jackson, sir, you've been charged with aggravated assault with a deadly weapon. Are there any priors on this gentleman?
One moment, Your Honor.
Judge, can I get into his ties to the community while they're doing that?
Sure.
He was born and raised in Fort Lauderdale. He's been living here for over 50 years. He only has $200 at most in his bank account. He's had a stroke 8 months ago, and for some time he was paralyzed on his right side.
Okay.
He's working with a nonprofit organization. He's trying to be in agencies for persons with disability, be a provider for people, disabled people. So he's working on doing that. We're asking the court to set a low bond in this case due to his health situation. He is seeking a place to live separate and apart from the alleged victim in the case. He went to college in Raleigh too, Judge. Raleigh, North Carolina.
Go ahead, state are there priors?
There's a petty theft in 2007. Spent 15 years for possession of. Is that what they would be?
Possession with crack cocaine. 15 years for finding supervised release. Possession with intent to distribute crack cocaine.
Oh.
Possession with intent to distribute 15 years, Your Honor.
That was 1987.
What, distribute what?
Crack cocaine.
That was 28 years ago, Judge. That's all he has?
2007 petty theft.
Okay. Now, sir, do you have contact with the alleged victim?
I did not.
So the court's going to set your bond today. Based on these facts, based on your criminal record, you allegedly tried to stab someone with a pair of scissors.
No, sir.
Court's going to set your bond at $7,500 today, sir. And you can bond out.
I don't have that kind of money, sir. I want to say that everything. I'm paralyzed now, trying to seek disability. I don't have a way out, but I run support groups. It's at St. Anthony's Hospital for Disabled, and I'm trying to do some things. This is not. I rolled her back to the house and was arrested.
Thank you, sir. We're gonna leave your bond at $7,500.
Judge, can we do a med screen and will the court reconsider it? He doesn't have a violent past.
Court's made a ruling on the bond.
I didn't do it.
Delris Wilson Edwards, no contact, directly or indirectly. No contact with her, directly or indirectly. Stay 500 feet from her at all times. That is where she lives, works, goes to school. Anywhere in between, you're not allowed to possess guns, firearms, or ammunition while you're on release. Thank you. How about Brian Richardson?
Medical reset.
Med? Okay, we'll set that for today's Tuesday, Wednesday p.m.
Just make a note to have one brought back down. Richardson, could you just make a note to have that one brought back down tomorrow?
I see Danielle Richardson, Jamel Edge, and David Graves.
Foss, I don't know if I told you, I got it, I'm printing it out now. The affidavit.
So you have two warrants. Count 1, 2,250. Thank you.
Judge, this is David Graves.
Where's Danielle Richardson?
Nurse if necessary.
Paul Ryan, do you have Danielle Richardson up there?
No, we don't have Daniel.
All right, Jamel Edge.
Bonded.
Bonded?
Yeah, I gotta do, yeah. I'll talk to you.
David Graves.
I
Sir, you have a battery. The court finds probable cause on. State of their priors.
just one more.
Sir, your bond's posted. You'll be out of jail shortly. No contact, directly and indirectly, with Phil Titta. No contact with Phil Titta. Stay 500 feet from him at all times. Thank you.
Yeah, I know we talked about that.
Missy Courtney case.
North Broward Jail.
Where's Courtney case? Sir, you're charged with 2 counts of voyeurism, resisting arrest, trespassing, loitering or prowling. Court finds probable cause. Steve, do we have any priors on this gentleman?
Are you serious? One moment, Judge. Out of where?
Get into his ties to the committee he does go to school at Palm Beach Community College. He lives with his mother in Boca Raton. He's been living in South Florida all his life. He does have money in his possession to bond out. He wanted me to ask the court if the court was inclined to resolve the case. If the court is not inclined, he would be looking for access to his property to bond out or contact his
Does he have any
mother.
money in the bank?
He said he has no money.
No money?
He has money in his possession, but I think no money in the bank, right, sir?
And you, Patrice?
No money in the bank.
Oh, so you guys think?
Frankly speaking, I understand you're being told he goes to school, but at this point in time, I'm going to be asking that it be a level 1. Your Honor, I see he was arrested late December last year in Boca for stalking, and I'm also being told by pretrial release that he ended up resolving that case.
How did he resolve it? You know?
I'm being told he got a withhold.
He had another stalking from earlier last.
January 14th of this year, a woman in Boca obtained a non-expiring injunction against Mr. Case. And I'm sorry, what did you say, Patrice? From when? Hold on 1 second. I don't see that. I see a resisting without violence and possession of marijuana from Boca of last year. I don't doubt you, don't get me wrong.
Judge, if the court places him on pre-trial release with the GPS, I would ask for level 2. At least allow him to go to school.
Yeah.
And pre-trial release is pretty strict with their schedules. If they deviate, he's in violation. He's back in custody.
Go ahead.
And Your Honor, really, and I don't see anything other than what pretrial's mentioned, but really my rationale at this point is he just pled out a stalking just recently. He also had a theft last year. In January this year, another woman had to go to seek a court's assistance in keeping Mr. Case away from her. Now we have him essentially stalking, for lack of a better term, a woman to a friend's home, and then trying to look into the windows of this home, and to top it all off, he's found by the police only with a towel on.
Right. And this was in the evening, about 10 o'clock, right?
Your Honor, I just think at this point in time, now certainly, if the court is inclined to order level 1, the defense can bring more information, more testimony, but in abundance of caution, I just think based on recent events, the court has to take I think the court should take the most strict release conditions possible for the safety of the community.
Judge.
Allegedly, let me just read into the record. The court's going to set the bond, but go ahead. I'll give you a chance. Go ahead.
With an ankle monitor, with the GPS, they know where he's at all times.
Right.
You know, if he's out of range, or if he's somewhere where he's not supposed to be, he's going to jail. I mean, and then there may be some mental health issues. I mean, for one, maybe he needs a mental health evaluation as a condition of his pretrial.
Could be mental health, but then maybe it isn't mental health.
Well, Judge, just based on the behavior of my previous talking to him previously on the phone, I think there's something there.
Okay, well, In any event, the defendant allegedly followed a woman who was walking her
Let me see, turn your
dog
computer
near a
towards-
church. Followed her
the
back to her residence. He allegedly walked up to the front windows of the home.
Oh, I don't have
The
the
victim and a
wait.
friend observed this defendant walk up to the front windows of the residence, peering into the windows late in the evening. Walked around the residence, peered into several other windows of the residence, including the bedroom.
Patrice.
When the deputy pulled up,
We're
the deputy
referring to
allegedly
from
saw
That was
the defendant on the
injunction.
side of the residence walking away from the window.
Participants, and I see a
The
petitioner.
defendant turned and ran away from the deputy. The defendant had only a towel around his waist, no other clothing items on his person. He was taken into custody. And the backdrop to that is the defendant had a stalking case out of West Palm last year, and someone had to get an injunction against him to keep him away this year out of West Palm. So the court's concerned there's some ongoing behavior which puts the community at risk. I imagine these are women that you're allegedly stalking in the West Palm cases. Based on these, it's very concerning. You'd be willing to go at night up to somebody's window and peer in their window wearing only a towel. So the court's going to set your bond on count 1 at $2,500, count 2 at $2,500, count 3 the resisting. Court will release you ROR, the trespassing ROR, the loitering and the prowling. Court's going to set that bond at $1,000. Your total bond today is $6,000. You'll have pretrial release with a GPS monitor. The court will ROR in 3 and 4. Waive the cost. Court's not going to make it a lockdown, but the court will order this defendant stay 500 feet away from Anna Cipriano and Sobayan Surgo at all times, including the residence where they live, work, go to school, anywhere in between. Thank you, sir. Excuse me.
I don't know who that is.
Desmond Grant.
Can I say something?
No,
Can I say
don't say
something,
anything.
Judge?
Don't say anything.
You don't
Can
need
you
to
hear
say
me?
anything. All right, sir.
I was at the beach. I was at the beach last night,
Got it.
and I met this lady.
Oh, no. Don't say anything about your case.
Come on.
Yep. What don't say anything means.
Desmond Grant.
President of Maine.
Sir, your bond has been posted. You'll be out of jail shortly. Thank you.
Good job. See you
How
later.
about Navaldo,
Down the middle.
Late,
Out the door.
John
President of Maine.
Luke Carmichael. Navaldo Late, sir.
Late.
Late, license suspended, no driver's license. Speeding.
Yes, sir.
I have the defendant has no driver's license. I have here that he's lived here for, he allegedly has an international driver's license.
How long's he been here?
Looks like 3 years. So. All right. Sir, are you currently employed?
Yes.
Well, what do you do for work?
I'm a chef. Mama's Pizza.
Do you have any money in the bank?
No, sir.
Well, on the international driver's license, you've already gotten, looks like 1, 2, 3, 4, 5, 6, several tickets. Even got ones for no driver's license. 1, 2, 3. So since 2008, 2 in 2008, 2009, no driver's license. So it seems like you're on notice. You should get a driver's license. So I'm going to set your bond at 100 on count 1. Count 2, the court's going to set that bond at 500. And just remind you, sir, please stop driving. You have no license. Thank you.
Yes, sir. Yes, sir. Good luck.
How about Jonathan Colton?
President of Maine.
Sir.
Mr. Colton, DUI, careless driving. State, do you have any priors on this gentleman?
One moment, Your Honor.
No. Colton, how long have you lived down here in South Florida?
Judge, he's a 15-year resident of South Florida, 2 years at the same address. He works at CC Transfer Service. He's been there for 5 years. He has 2 children, age 17 and 18. Strong family ties, no money or real estate. He's hoping his girlfriend to bond him out. Wants the court to know that he volunteers training youth in amateur boxing.
Okay. For a DUI, drop to reckless driving. And right now, I don't know, it looks like it's... So I'm going to release you on your own recognizance, all right?
Thank you,
Yes,
Judge.
sir. Good job. Good luck.
Luke Carmichael?
How about Luke Carmichael?
Anybody want to wake up Mr. Carmichael?
Someone's still sleeping.
State, do you have priors on Carmichael?
One moment, Your Honor. Didn't he?
I'm moving. He's on there.
One moment, Judge.
Luke Carmichael, you had an indecent exposure, 2015.
He's had a lot recently. I got it. You got it.
2000, it was put out on April 17th of this year, indecent exposure.
Actually, yeah, and then he violated probation on an indecent exposure and theft. He's county sentenced. He just got out May 18th.
Okay, I'm going to send this to Judge Lerner Wren. Carmichael, sir, trespassing at Walmart. Are you currently employed?
No, he's not employed, Judge.
Do you have money in the bank, Mr. Carmichael?
No, sir.
So I'm going to set your bond today at $150. Just got out of jail recently on a petty theft and exposure. Not allowed to return to Walmart. I'm going to send you to see Judge Lerner Wren, sir. Thank you.
There you go. Down the middle, out the
How about
door. You can go
Madaro
sleep again.
Sanchez?
Spanish.
Yeah. Siete se, por favor. How about Waller Bennett?
Conti.
Is he there?
It's an MO case.
Conti, Judge.
Your Honor.
Conti, Your Honor.
Thank you, Your Honor.
Sir, you're here for consuming alcohol in public. Would you like to resolve your case today?
Yes, please, sir.
Plead
May
no
I?
if you plead no contest, the case will be over with today. We're not going to have a trial. We're not going to appoint an attorney. It's just wrapped up right now. Is that what you want to do?
Wait for the order.
Yes, please, Your
How do you
Honor.
plead,
No
sir?
contact. Thank you very much.
Okay, I'll withhold adjudication. Thank you. Good luck.
The next case is he's at no problem, but they advised me it's a medical reset. Richard Founds.
Okay.
He's in a wheelchair. He's blind. He's in bad shape. It's also an MOK.
Well, he may, if he's blind, he's panhandling in traffic. No, I'm just saying now that. Yeah, okay. I'm going to reset him for Wednesday PM. Yes.
I mean, he was trying to claim he found out through like a relative or something.
Excuse me. How about
Once he got caught.
Candid Whitus and Calvin Lewis?
Judge, I'm
Why
reviewing.
is it the main jail?
I'm reviewing the warrant for arrest, Judge. So just have a moment to look at it.
Sir, just give me a moment, sir. I need to review a document. Just stand by. Okay, we're back on. Now, Mr. Whitus, you are charged with count 1, attempted first-degree murder with a firearm. Count 2, attempted first-degree murder with a firearm. Those are both first-degree punishable by life felonies. Am I correct, State?
Yes, Your Honor.
Now, are you seeking a foreclosed bond and release conditions at this time?
Yes, Your Honor.
Now, there must be a showing
Well,
of proof evident presumption.
Your Honor, I haven't finished reading through this.
Oh, sorry. The defendant is also known as Candid Meredith. That's how he's referred to. Give me another moment. I need, both sides are still reading. Ready to go?
Keith,
Everybody ready?
How could that be? I understand he's charged with this.
So you're charged with 2 counts of attempted murder, 1 possession of a weapon by a convicted felon. State, are you seeking a foreclosed bond and release conditions on count 1 and 2?
Yes, Your Honor, based on the warrant affidavit.
Okay, now let me ask you. Go ahead. No, just make a brief showing if you don't mind.
Your Honor, based on the investigation by the detectives, Mr. Whitus, aka Camden Meredith, has been identified by two witnesses. One of the victims of the shooting, and another witness that was not a victim of the shooting, with 100% certainty is the person that shot and Charlie Pippins Jr. and Jasmine McElroy. Admittedly, and the detectives don't try to hide it, there are witnesses that claim that it was Mr. Meredith's girlfriend who claims that she did it herself. The detectives give reason why these were biased statements, Your Honor. The detectives note that his girlfriend made no mention, denied that Mr. Whitus was even there present at the scene. And, Your Honor, frankly speaking, I don't know what reason there would be for these people, one of which doesn't seem to have any connection to these people, to say that somebody else, to lie about who shot them and let the person that actually did shoot them go free.
Let me ask you this, Steve.
Yes, Your Honor.
You got 2 witnesses said it occurred. Is that one witness who claims that she's the shooter? Is that enough to undermine proof evidence presumption grade?
Your Honor, the reason I think it is not enough is because it appears that there's evidence that Mr. Whitus was present. If she had said, yes, he was present, but he didn't do it, I did it, that would be one thing. But the fact that she's effectively telling police he wasn't even there when this happened, I think undermines her entire story.
It may undermine it, but is it enough to weaken the proof evidence presumption?
Yes, Your Honor, because it would appear that she's protecting the actual shooter, and I believe she has reason to. As you see, Your Honor, in the affidavit, he's on probation for attempted second-degree murder. He's facing very serious consequences, Your Honor, and I think that would give her reason to try to protect her boyfriend. And that's why to go so far as to claim he wasn't even there when this happened.
Go ahead, defense.
Judge, this whole thing turns on the credibility issue. Now, when credibility is at question, then that becomes an issue for the jury. It doesn't rise to the level of proof evident presumption. Great. And when you have other witnesses saying that Mr. Pippins pulled out a gun, and then there are other witnesses saying that they saw Kirsten, I believe that's her name, grab the gun in self-defense, I think that raises an issue of credibility. Let the jury determine whether or not those witnesses are credible or not. But I do not believe in this circumstances it rises to the level of proof evident presumption. Great. In the warrant for arrest, the cops are making a credibility call with regards to the arrest. I don't think it rises to that level, Judge.
Well, and Your Honor, that's interesting, because I would note that, yes, witnesses said he had a gun, but doesn't appear that the gun was recovered, and he certainly couldn't have gotten rid of it. He was shot, and he had to crawl, and he's in a coma. He had to crawl to a home. He couldn't have gotten rid of it. So it doesn't appear that anyone would have had any ability to get rid of this so-called gun, and that's part of the reason why, and these detectives note that they took these statements, and it appears they're not credible.
When the cops are making credibility questions with inconsistent statements, I don't think that rises to the level of proof evident presumption grade.
Based on the totality of the circumstances contained in the warrant to arrest and the affidavit, the court will find proof evident presumption grade today. This defendant attempted to murder Charlie Pippins and Jasmine McElroy. The court does take into consideration there is a bit of conflict, but even with that taken into account, it does seem rather clear at this point that the state has met its burden of proof evident presumption grade. And
Your Honor,
go ahead.
That being,
Judge, I would ask, even though I would voice my objection for the record, I don't think these facts and circumstances rise to that level. And
Understand.
second, I would ask the court to exercise discretion under Preston v.
Okay, under the
Simpson.
Preston case and the Keel case, the court believes at first appearance where the state attorney's office is requested to foreclose bond and release conditions. The court is of the opinion, based on Preston and Keel, K-E-E-L, out of the Fourth Court of Appeal, this court is without discretion in setting up any type of bond or release condition. The defendant's only method of relief is to have a full-blown Arthur hearing in front of his trial judge. Now, that being said, is he a convicted felon?
Your Honor, first off, he is a convicted felon on multiple cases, including 2 cases that he is currently on probation for till about 2023, one of which is for aggravated battery, great bodily harm. The second case is attempted murder in the second degree.
Count 3, okay, so, I'm just gonna assume he has no money. I have to set a bond on 3,
Yes,
right?
yes, Your Honor.
Assuming he has no money and excellent ties to the community, I'm gonna say his bond at $50,000 on count 3. Have those been revoked?
No, they would have to be a 94806, Your Honor.
What?
They would have to be a 94806.
Summers.
The aggravated battery is 10-13211 CF10C. The 09 is 22179 CF10A. That's the attempted murder.
Do 197.
0922179 CF10A. Okay.
Sir, today you're going to be held without bond on count 1 and 2. The court's going to order no contact with Charlie Pippins, no contact with Jasmine McElroy, directly and indirectly stated. Who was that witness? No contact with Kirsten Myers, directly or indirectly. No contact directly or indirectly with, hold on, I've got one more. Kira Calloway, no contact with her directly or indirectly. And no bond on 1 and 2, count 3, 50,000. And you're going to be held on probation violations pursuant to Florida statute 948-10-13211 CF10C and 09-22-1979 CF10 Alpha. You'll be held without bond on those. Thank you. I got it. Ma'am, you want to come on up? Do you swear or affirm to tell the truth, to translate from English to Spanish, Spanish to English truthfully and to the best of your ability? Yes, I do. Thank you. Good afternoon, Mr. Sanchez.
We can't hear. We can't hear anything. Somebody needs to fix that microphone because we can't hear in here.
Well, you know, it's really, I noticed it's only when the interpreters come in.
No. It's the only time we complain about it, Judge.
Excuse me?
It's the only time we complain about it. We can't hear from that microphone all day long.
Really?
Really.
Hold on, we have our handy dandy repair person in.
Yeah, you got to keep that with, because
Hold it, we're doing a system check. Just give us a moment. All right, you want to give it a try? Good afternoon, Mr. Sanchez.
Sánchez, ¿me oye?
Can, can you hear?
Sí, sí.
Okay. You've been charged with DUI, no driver's license. Do we have any priors on this, gentleman?
One moment, Your Honor. No, Judge.
No? Mr. Sanchez,
Nunca.
how long have you lived in South Florida?
12 años.
Do you have money in the bank?
No.
What type of work do you do?
Trabajaba en construcción.
So I'm going to set your bond on count 1 at 500, count 2 at 500. Your total bond's 1,000. It appears you have no driver's license. So you're not allowed to drive. And the court is concerned that you're driving while you're impaired. Thank you, sir. Missy, Kelvin Lewis.
How much they say is the $1,000, $100 to a bondsman.
Okay.
Do
Do we have any other Spanish speakers over there?
I don't believe so.
Okay, thank you. How about Kelvin Lewis?
Main jail.
Sir, reckless driving. And I'm looking at your driving record right now, a DUI. So, leaving the scene of a crash, license suspended, DUI, open container of alcohol. All right,
Is this Kelvin Lewis, Judge?
Kelvin Lewis right here. Kelvin Anthony Lewis, right?
Yeah, I don't see anything about leaving the scene. I don't see anything about open container.
I'm talking about his driving record. Sorry about that. Okay. Sir, count 1, reckless driving, 2, DUI. Says your second offense. Expired driver's license, license suspended, habitual. The court finds probable cause. State, do we have any priors? Well, we already know. Let me ask you.
Whatever she put over there. Yes, one moment, Judge. He was arrested May 9th. On an out-of-county hold for uttering a forged instrument and grand theft out of Brevard County. He was picked up May 15th.
Got it. So I'm going to let you bond out today. Are you working?
Yes, sir. I'm still working at Joe's Crab Shack.
He's been working at Joe's Crab Shack for about a year, Judge. He's got a 13-year-old daughter that he takes care of. Strong family ties, no money or real estate. He's going to have to self-bond.
Got it. So the court's going to set your bond on count 1 at 500, 2 at 1,000, and count 5 at 750. That's based on your open case out of Brevard and your prior DUI and the facts of the case. Thank you.
Good luck. I'll let Mr. Wilcox know.
Zikria, James Ashley,
President.
and Ryan Lear.
Zikria? Yes. Zikria has declined the services of the public defender.
Sir, battery on a police officer twice, resisting arrest with violence, resisting arrest without. Do we have any priors on this, gentleman?
Trace, do you have anything?
We're going to ask him to lower the $10,000.
Sir, are you currently employed?
Yes.
What type of work do you do?
I breed cats.
Excuse me?
I breed cats.
You breed cats?
Yeah. Yes.
Okay, and how long have you been in the cat breeding business?
Like 25 years.
Do you have money in the bank?
Yes.
How much would you say you have?
I have about 20,000.
Oh, okay. Well, allegedly
Your Honor.
struck a police officer in the face with a fist and kicked another officer in the leg and kicks in the palm. Okay. Got it.
Your Honor, I was under the influence of drugs.
Oh.
Sir, the court's going to set your bond on count 1 based on the level of violence, based on the facts of the case. $5,000 on count 1, $2,500 on count 2. Count 3, resisting arrest with violence. Court's going to set that bond at $1,500. And count 4, resisting arrest without violence. Just based on the level of violence, sir, and the facts of the case, your total bond today is going to be $9,600. Thank you. You can bond out. How about James Ashley?
Main jail. We have an argument.
Aggravated battery with a deadly weapon and a warrant on a misdemeanor contempt failure to appear. Count 2. Count 2 is a no bond hold. Count 1, what would you like to say about the aggravated battery, sir?
Basically, Judge, this is Mr. Ashley's apartment. The people who were staying there were staying at his pleasure.
Right.
They're not on the lease. They're guests. He revoked their right to be there, and they broke into his house. Apparently, I don't know how they. It seems to me they probably cut themselves when they broke into his house. It's no allegation that he picked up a piece of glass. The only allegation is he was trying to sweep up the mess that they made. So I'd argue there's no probable cause for an aggravated battery, and ask the court to release him on his own recognizance. It's not a situation where eviction would be necessary just because they're not on the lease. Okay, it's just you invite a guest into your home, and you can uninvite a guest into your home, and they're not allowed to break into your house after you kick them out.
Mr. Miller, there's an issue you bring up, which from time to time you do. There are facts that are not in evidence. I mean, you say that they're not on the lease, and I would just say, how do you know that? I mean, your client at this stage could say whatever, and that doesn't mean it's necessarily true. But these facts come out, and I don't know how to verify these facts. I mean, are they on the lease?
Well, you can verify the fact that they. You can verify the fact they broke a window to this man's house.
Right.
You
well,
can
the police
verify the fact
officer saw
that
that much.
And you can verify the fact that he was cleaning up the mess that was made. You can verify the fact that they were outside of the house breaking in. I mean, that's in the police report.
Right. Go ahead.
And, Your Honor, and if based on the officer's report, where he states he's investigated this, and if it reveals that they were illegally evicted, then they are allowed, and they still have a right to be present in that home, and they are allowed to enter that home, even through a window, Your Honor. I think on its face, there's probable cause. Now, certainly, I understand the court taking these other allegations when setting release conditions. I understand that. But on its face, Your Honor, at this point in time, there is probable cause.
Okay. I'm going to find probable cause. Does he have any priors?
The only thing I see, Your Honor, 2012, he pled out a felony to petty theft.
Sir, I'm going to lower your bond today in this case to I'm going to lower it to $2,500. All right, sir? Count 2 is going to be no bond. You got to go straighten that out with your judge. Thank you.
I just asked for no victim contact.
No contact with the alleged victim, sir. That is
okay. All right. Wait.
Johnson St. Cyr and Herbie
Florimar.
Florimar
and St. Cyr. Thank you. Ryan Lear. Ryan Lear.
Looks like that's a med reset, Judge.
Okay. I'm going to pass it right through. No bond. William Petre.
Judge, he was on transport from Maine to North Broward. I don't know if he's there now.
Jaquan Robinson, Dana King, and Rodolfo McGovern. Petre.
They're saying med reset for Petre.
Maybe at the North Broward jail. That's what I'm saying. He was being transported.
I'll set him for Wednesday p.m. All right. Petre.
Robinson?
Yeah.
Okay, Mr. Robinson, violating probation. That's a no bond hold. Thank you. How about Danae King?
Main jail.
Go ahead, state.
Patrice, do you have anything?
So do you, you're 32 years old. What do you do for work?
Judge, he works at Southwest Logistics. He's been living in South Florida his entire life, 9 years at the same address. Strong family ties, no money in the bank. However, he does own his own home, and he's hoping that his friends will help to bond him out.
I'm going to release him on his own recognizance. Thank you.
Thank you, Judge.
Rodolfo McGovern.
Good luck. Thank you, sir. Yep, Mr. McGovern is present. Judge, we need a phone order for him so that he can make some phone calls.
Sir, burglary of a
to help
dwelling,
somebody
grand
bond him out.
theft. You have a writ on count 3, $1,164 purge amount, and clear funds probable cause. Steve, do we have any priors on this gentleman?
Patrice. He's got 18 things going on.
All right. Anything to say on behalf of this defendant, Mr. Miller?
20-year resident of South Florida, 3 years at the same address. Works at Hodges Roofing. He's got a 15-year-old son that he takes care of. Strong family ties, no money or real estate. He's going to have to self-bond.
Go ahead.
And we need that phone order.
Where's this out of? Southampton. Southampton would be New York, or would it be?
So, are these? Well, they could be
Mass?
East Long Island, or it could be Massachusetts. If it's New York, it's Suffolk County.
Got it. Got it. Okay, sir, court's going to set your bond on the burglary today at $7,500. Count 2 will be $5,000, the grand theft. You got a purge amount. It's based on your lengthy criminal record, burglaries in the past. So, thank you.
All right, good luck. Judge, we have a recall from this morning, Jeffrey Foster. I provided the court with the petition for the restraining order that was pulled by Mr. Foster on the 15th of this month. Sorry, the 16th of this month.
Why did we find Danielle Richardson anywhere?
I'm in church tonight.
Danielle Richardson, did we find her? 2 misdemeanors.
Danielle Richardson bonded.
She bonded? Okay, thank you. Okay, Mr. Miller, we're going back to you. Mr. Miller, Jeffrey Foster. The issue, aggravated battery. So the issue you were bringing out was younger men, much younger men, and I don't know. This defendant had a restraining order on him?
No.
What was it?
Yes.
I got it.
When was?
There is a
What's the date
restraining
on?
order.
What's
I've
the
got it
date
in
on the
my hand.
injunction on the petition?
16th.
No.
the defendant pulled a restraining order on the alleged victim. I have it in my hand. I provided copies to everyone in that courtroom.
Hold it. Wait, just stop. I'm holding a.
May 18th, thank you.
I'm holding a.
16th. There was not an injunction at the time of this incident.
I'm holding a petition for injunction for protection against repeat violence. Jeffrey Foster, the petitioner, respondent Volvic Charu. Now,
which is the alleged victim in this case.
Well, it says the alleged victim is Volvic Durant.
And Your Honor, I believe, and I don't know the rationale, but it appears same person, different last names.
Okay.
What I'm referring to, and just, I'm not denying that Mr. Foster sought a petition and a temporary, based on what he's written, has been issued. What I want to be clear, because the impression I got this morning is that there was an injunction ordered at the time of this occurred, and that's not the case.
The date of this injunction that you gave me is May 18th. This allegedly occurred on May 16th. So are you still saying that there was an injunction in effect at the time this incident occurred, sir?
Okay. Judge, this petition, which I guess you say it was on the 18th, I have to believe you.
Well, it's on the last page.
Alludes to the incident of May 16th, okay, which is the incident that's reported in this. And what I told you is that he pulled a restraining order against this guy, okay, and that the guy, the alleged victim in the case, is much younger than him, was threatening him, and that my client had every right to defend himself.
Let me back up a little
That's
bit.
what I said.
Let me back up. I thought you said earlier there was a restraining order in place when this took effect. That's what I thought.
I didn't know when the restraining order was. All I know is my client told me that there was a restraining order. I now have the restraining order, and I gave a copy to the judge, to the court.
Let's clarify something. The
You have to
petition
say it. I
for
can
that
give it to
restraining
my-
order was not requested until 2 days after this
I couldn't get it there.
criminal
so
case
I
we're
had to
hearing on
get it
today.
Monday.
So I just want to clarify that. And
Okay. But it was before he was arrested on this case.
Okay.
Okay, and it alleges that he was surrounded by several people, and the respondent was the alleged victim, Volvic, stop now, threatened to knock me out and spit on me. He also said he didn't care about my age and that he would knock me out. Suddenly, Volvic punched me on the side of the head, and I had to defend myself. He spit on me and ran off. And then you'll see for other prior incidents, this has been going on since March. This Volvic Duvernay or Charu, whatever his name is, was born on July 30th, 1990, making him 24. I said 23. I apologize. Okay, and my client is 50. How old are you? 56 years old.
57
Okay,
this year.
so he's a much younger man. He surrounded my client, attacked him. My client had every right to defend himself by whatever means necessary. I think that he was reasonable in his response, and I'm asking the court to ROR him.
All right, well.
I'm not a very well person. Not way
I also have some additional information, Your Honor. I actually spoke with, and he's mentioned the report, Detective Fargnoli, who got a statement, a sworn statement from Mr. Foster, and the story goes a little different. Your Honor, what the law enforcement was told was this started when Mr. Foster had a fight with the victim's brother over a parking space. Mr. Dubernat got involved to protect his brother and make sure see what was going on and to stop it. At that point, Mr. Foster ran into his house and came out with a knife, and Mr. Dubernat got stabbed. Now, in full disclosure, Mr. Foster was telling Detective Fargnoli that he was surrounded by people outside his house. He was scared. He pulled a knife, and he acted in self-defense. Detective Fargnoli confronted him with, and he made it up, but saying that there's video. What about the video surveillance that shows you entering your house? At that point, Mr. Foster changed his story. He said, yes, I went into my house, but that was to change my tie and jacket. He was then confronted with, well, if you were in fear of these people, when you entered your house, why did you come back outside? He did not have an answer for that. He also did not have an answer for, if he was in fear, why did he leave his knife behind? Your Honor, Detective Fargnoli, and I spoke with him, his statements were not consistent
understand.
The victim and multiple witness statements were consistent with what the victim alleged to have occurred.
I understand.
Also,
the court's gonna find probable cause. We're not gonna try the case today. So
I'm not looking to try, Your Honor. I just wanted to bring, because I know that he filed for an injunction 2 days later, but it doesn't appear to be consistent with what he told someone else.
is there anything you want to say on behalf of this defendant, ability to post bond?
One moment, Judge.
Yes, Your Honor.
Tell me what his priors are.
2008, delivery of cocaine. In 2005, he was arrested for domestic violence, false imprisonment, felony battery due to priors, and resisting without violence. Now, those charges were dismissed on competency grounds. In 2008, he had a battery. In 1992, he had another battery. In 1984, he had a possession of cocaine with a VOP.
And Judge, just for the record, I have in my notes here that the defendant pulled a restraining order on Monday on the alleged victim. That's what I put in my notes. That's what I would have told the court.
Okay. Now, let me ask.
He's been living here his entire life. He's been at the same address for how long?
I've been there 5 years.
5 years. He's currently disabled, receiving SSI, strong family ties, no money or real estate. He's hoping that his friend Pastor Akins will bond him out, and he's advising that he is currently studying to enter the ministry.
We helping drug get out of the setting. We helping people out.
Your Honor, my concern, Your Honor, I'm going to be asking for a $15,000 bond. Mr. Foster has a history of violence. There is evidence before the court that his explanation of what happened is just not credible, that there's an account from multiple witnesses that contradict his story and corroborate the victim's story, which, so, Your Honor, I think that's an appropriate bond.
The court's gonna set your bond at $5,000, pretrial release, GPS monitor, waive the cost of the monitor based on your criminal record, the facts of the case, 2 prior batteries. Court will order no contact with Mr. Volvic Charu.
Here's the one issue with the GPS, Your Honor. It appears that they are neighbors.
We are neighbors.
I'm just bringing to the court's attention.
Judge Kaplan ordered a 5-foot buffer zone
I don't know.
in favor of Mr. Foster.
But that did not have a GPS component though, so.
And that was the temporary injunction. There will be a final hearing.
June
and I don't know if the detective's even going to might appear at that to tell Judge Kaplan. I don't know, because there's been an investigation that doesn't support these allegations. But, you know, I'm just bringing it to the court's attention because I don't want to see further complications. Okay. 5 foot. I'm going to take off the GPS. No GPS. Stay 5 feet away from this man at all times. Thank you.
Thank you, Judge.
Judge.
Grips it extra hard.
Prior to doing the
You
second,
can tell when it's an angry rip.
It has a dialect to it.
Judge.
He's going on pre-trial, but no GPS, but he must get.
Go ahead.
Are pre-trial?
State, are there any things that have not been filed?
I believe there's some, Your Honor. I just need one moment.
Yes.
You can go out there with the tape measure. Thank you. Appreciate it. Just give me one moment, Your Honor.
Judge, while he's...
Go ahead.
No, I just want to bring up, Judge, there was a case that was magistrated on Friday, a murder case. Apparently, he was booked incorrectly at the main jail under premeditated murder, but on the booking, on the PC, it was a murder without premeditation. The homicide attorney wanted me to have him remagistrated on the correct charges because confinement status or booking won't change the charge, what he was booked on, and they advised us that he would have to get magistrated again, remagistrated on the correct charge. So I'm asking just to place it on tomorrow afternoon's docket. I emailed Marge about it. But she would.
And-
No, but yeah, but she responds to my email. Oh, I assumed she was here. I got an email, but I'm asking just will the court just consider placing that matter on the docket to just re-magistrate him? The homicide attorney wants to be here and family members want.
And Your Honor, I'm fine. We can put it on the record under the case number. I will concede. It's just like it said on the PC affidavit, murder with depraved mind without premeditation. I don't think it is necessary to bring him down, a murder defendant, down to that courtroom again, Your Honor. I don't think it's necessary. He was present for the court's entire first appearance.
Bring him down.
Judge,
It's really kind of a ministerial change. I mean,
well, his family wants to be present. The attorney wants to be present. That's for that. So I'm just asking on behalf of the about.
It seems like the big thrust of the thing was Friday night.
Well, what I'm trying to say is that I can tell you that what was referred to me was that the only way they can change that is confinement status supervisor said they'll have to correct it and match the statute. The statute was incorrect.
I could correct it, but do you really, want to have a big, the big event on something, and because
I don't think it's going to be.
The person's not going to be leaving anyway, right?
Your Honor, in
He's
fairness,
not. But they're saying the only way they will correct it to match the statute is he has to be remagistrated. This is
Your Honor,
part confinement status.
It happens all the time, Your Honor, where someone gets charged with murder. Like instead of today where you find attempted murder and it stays in the system as murder, but on the findings you found PC. And Your Honor, as far as the family, frankly, my understanding is they were here on Thursday when it was reset to Friday. They didn't come back Friday. They had their chance to be present on Friday, Your Honor.
But
I don't see what harm. I mean, like what? How?
If it's just a ministerial change and the guy's not going anywhere anyway,
The cost.
we have to bring the family in and drag them through it again. I mean,
On a murder case, I think the cost, the potential risks outweigh the reward, Your Honor.
I don't know.
The jail has to have security.
He's already at the main jail.
You know what? Let's not do it and blame it on him, right? Okay, so.
All right, Your Honor, I'm almost done
Okay.
getting these. Your Honor, all the remaining 30 days are filed. If you want to go through them, bring them up.
Tell me which. So.
Jeffrard, Jackson, Bryant, and Miller.
And what about Christopher Lyric?
That's a second look.
And Kendrick Wallace?
We did that earlier. His girlfriend was here. She's very happy that you let him in.
Gotta remember. Okay, so. Okay. Now. I see David Bryant.
Conti, Your Honor. Come on,
Mr.
David.
Bryant. Hi there, sir.
Right in front of the podium.
Mr. Bryant, we're here on case 15-5307 CF10. Mr. Bryant, we're here to see whether the prosecutors filed a formal charge on you. I'm looking here. It says state filed a formal charge on May 26, 2015. I will read it to you. You're charged with 1 count of burglary of a dwelling with a battery, 2 burglary of a conveyance with a battery, 3 kidnapping, 4 carjacking, 5 robbery. I'm going to look on the last page. Scott Dressler filed this charge with the state attorney's office, signed and sworn to May 26th. Any comments from the defense? Mr. David Bryant, the motion to release you today will be denied. All previously set bonds and release conditions shall remain in full force and effect. Thank you. Okay, Missy Gennard Gaffrard. Gennard Gaffrard.
Right, you're in B5? Okay.
Where's Mr. Gaffrard?
What's the first name, Your Honor?
Janard, Janard.
Janard. This is Janard. North Broward. Janard. Come on. Right here, Your Honor.
Okay.
Stand right there.
Mr. Gaffard, North Broward. Sir, we're here to see if the prosecutors filed a formal charge on you. 5/26/2015, State of Florida filed a formal charge. I'll read it to you. State of Florida versus Janard Gaffard. Count 1, 2, and 3, aggravated assault on law enforcement officer. Count 4, aggravated fleeing or eluding. Count 5, grand theft auto. 6, resisting arrest without violence. I'm going to look on the last page. Sworn to, executed by Alex Urella, State Attorney's Office, May 26th. Any issues by the defense? Sir, the motion to release you today will be denied. All previously set bond and release conditions shall remain in full force
Can I have a
and effect.
reduction, please? Can I have a bond reduction, please?
Sir, you'll have to take that up with your trial judge. Thank you. Missy, Richard Jackson.
Come on, Richard. Copy, Your Honor.
Mr. Jackson.
Richard Jackson.
Got
Yes.
it. Okay, Mr. Jackson. Need to find out whether the prosecutors filed a formal charge on you. Give me a moment. Richard Jackson, I'm looking right now. State of Florida filed a formal charge May 26, 2010. It says the State of Florida versus Richard Charles Jackson, burglary of a conveyance. And I'm going to look on the next page here. Hold on. On the next page, Alex Urella signed the document May 26, 2015. Anything from the defense? Mr. Jackson, today the motion to release you will be denied. All previously set bond and release conditions shall remain in full force and effect. Thank you, sir.
Okay.
Missy, Desmond Miller.
Copy, Your Honor.
Hi, Mr. Miller.
Hey, how you doing?
I want to see what's in the computer here for your case.
What?
Mr. Miller, I'm going to go down here to right there.
Gonna be ready?
5/26/2015, State of Florida filed a formal charge on Mr. Desmond Miller.
Do it.
I'm going to look here, charged with 1 count of felony petty theft. That was signed and sworn to by Scott Dressler, State Attorney's Office, May 26, 2015. Let me ask the defense, any issues with this? Today, sir, the court will deny the motion, release you ROR. You'll be, same bond release conditions shall remain. Thank you. How about Christopher Layrick?
Copy, Your Honor.
That's the second look, am I correct?
On Larich, yes.
Okay, Layrick, how come you haven't bonded out of the jail yet?
Your Honor, I don't have any money at the moment.
How long have you been in jail?
I think this is day 13, Your Honor.
Yeah, he definitely doesn't have Broward priors.
Did he come in when I was sick, do you think?
No, he came in, well, no, I don't,
Weekend?
it was when Judge Fell was on the bench. I don't know why you weren't here, but it wasn't last week when you were under the weather.
Do you still live on 6th Place in Plantation?
Yes, sir.
Okay, I'm going to release you on your own recognizance today, all right?
Your Honor, may I ask the conditions of my release?
Hey, you don't have any, just...
Thank you, Your Honor.
Yeah.
Thank you.
Don't smoke marijuana.
Thank you, Your Honor. I won't. Thank you.
And don't have it within 100 feet of your body, all right?
Absolutely. Thank you.
Thank you.
Everything that happened right there, that judge will hear you. I couldn't even go to the judge meeting.
Can I see Terrell Griffin?
North Broward, Your Honor.
Okay. Assault on a public or private education employee, let me look here. Defendant made threats to slap and punch the victim, Emmanuel Hunter, assistant principal at Whispering Pines Elementary.
Judge, school ends on June 4th. He's 18 years old. His family lives down here. He's a resident of Lauderhill. They can't afford the bond that's currently set at this time.
This was set by Judge Tudor, and I think the concern was, Your Honor, the biggest concern was when the allegation that he was asking for a pen to stab the assistant principal or the employee with.
Judge, with the summer break and due to the fact that he is a mental health client, would the court consider lowering the bond in this matter? He is only 18 years old. Or maybe place him on pretrial release with some conditions.
Your Honor, frankly speaking, I think this is just, and while he's charged with a first-degree misdemeanor, the potential violence alleged in this case, I think without more knowledge, it's one thing to go in front of the assigned division and have, a caseworker or someone with some information, but just to say, well, there's a mental health issue, so we got to get him out.
Why is he sent to Judge Lerner Red?
I don't know if she'll take this, but I mean, if you wanted to, the worst she could do is send it back out.
I'm going to send this over to Judge Lerner Red. Can I have this is Mr. Is it Terrell Griffin?
Yes, Judge.
So I'm going to send you over to see a special judge on your case. You'll be there in the next day or so, okay?
Okay.
Thank you. Okay, now, how about Cassandra Manco? Ms. Manco, ma'am, petty theft, resisting a merchant, criminal mischief. How come you've not bonded out of jail, Ms. Manco?
I have no money and no family right now.
How long have you lived out here in South Florida, ma'am?
24 years.
Were you working before you were put in jail, ma'am?
Trees, what was the issue here?
No, I'm on SSI.
There was some issue here. I mean, I can tell you, Judge Tudor is pretty open to putting people on pretrial.
Did she have any priors?
Your Honor, I'd have to check. I don't have it written down in my system. Judge Tudor doesn't do what you do in writing them down on the findings, so.
You can call me everything, you ain't gonna miss nothing.
I mean, that's the thing I can tell you, is that there must have been something aggravating for Judge Tudor not.
Tried to allegedly fight the people at Walmart. After the fight, the defendant was in take back loss prevention office. We should get to fight again. The deputy said they got there to take her into custody. She started kicking and pushing to resist arrest. She was put in handcuffs. Asked her name. Her response was dropping the N-bomb. I'm not going to get into it.
And it might be just. Now that you're reading more of this, Your Honor, it could have just been, frankly, Judge Tudor said, you know what, based on these allegations.
Kicked out the car window.
Ma'am,
I'm going to leave your bond where it is, all right? Thank you.
I think just, okay. That's the thing, and it's just based on these allegations that.
Thank you. Chrislet Ondina. Oh, brother. Oh, brother. Where is she? Where is Chrislet Ondina?
Yes, Judge.
This is okay. Loading or prowling, sir? You've been in 6 days. How come you have not bonded out of jail, sir?
I had no money, sir.
Hey, so from what I can tell, the case that this is about is just count 2. Because you filed count 2. But here's the problem. And by the way, here's the problem with something. You know how you filed 4 charges total on 15-5400 CF10A? Yes, you charged him. He hasn't been served with that yet because if you look at
So would you like to resolve your case today?
He's still only being held on a total of 3 counts.
Would you like to resolve your case?
Well, he can't.
Say it again, Judge.
Would you like to plead no contest today?
Has a no bond hold on.
Yes.
Oh, yes.
Yes, sir.
You plead no contest, the case will be over with today. There'll be no trial. The case is closed. You go home today. Is that what you want to do?
I know. And
Yes, Your Honor.
How do you plead, sir?
No contest.
Okay, I'll accept that, sir. I'll withhold adjudication. Thank you.
Thank you, Your Honor.
I have no idea. They need to get it done.
Yeah, that's right.
You might want to have Edna contact the jail tomorrow or the clerk to see what is it that needs to be done to get him served. Add charge with those 2 new counts that you did. I think just 2 more counts of the same. You see, here's the thing. If you look at the SOKX, it shows he's being held on 3 counts, right?
Just give me an order.
1 and
This
2
court
are
notes that the
legal
statute
lascivious and count 3
was
is
incorrect. The correct
battery
statute
special
under this should be
conditions.
that. Okay, everyone.
Now, counts.
Thank you,
1 and
everyone.
2.
We'll see everyone back here tomorrow morning, bright and early at 8:30 in the morning. We're
Except
out
you
for
added
2:35. Thank you.